I'd like to talk to you for the next few minutes about arbitration. Arbitration is a method of resolving disputes by which the parties agree that a third party, the arbitrator, will decide the outcome for them and that they will be bound by the decision. In other words, arbitration is a creature of contract. The parties must agree through a contract to arbitrate. And there are basically two types of agreements to arbitrate. The parties can enter into a pre-dispute arbitration agreement, essentially agreeing that if a dispute arises in the future, the outcome will be determined for them through arbitration. Pre-dispute arbitration agreements are frequently seen in labor contracts and commercial contracts, where the parties agree that if and when disputes arise, they will be resolved in arbitration. Post-dispute arbitration agreements, in contrast, are created after a dispute has arisen. Here, the parties agree that this particular dispute will be resolved through arbitration. As a creature of contract, the parties to an arbitration agreement have great latitude in deciding the parameters of arbitration. Basically, anything goes so long as they agree. They can decide who will be the arbitrator or arbitrators. It could be three lawyers selected by a judge, or it could be their Aunt Sally, depending on what the parties want to do. They can decide what rules will apply to the arbitration. For instance, they may decide that biblical law, the law of Ohio, or no law at all, will apply to the resolution of their dispute. They can decide if witnesses will be called and how many, where the hearing will be held, and how long the hearing will last, and who will pay the expenses. Arbitration has the promise of being efficient, informal, and less expensive than litigation, if that's what the parties want. It also can take on all the trappings of full-fledged litigation, depending on the terms of the parties' agreement to arbitrate. Both federal and state law encourage and facilitate arbitration. The law flows from the Federal Arbitration Act, which was enacted in 1925. The purpose of the FAA was to resolve any doubt about the enforceability of agreements to arbitrate. The Federal Act and the corresponding state statutes provide that arbitration agreements, quote, shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. In other words, an agreement to arbitrate is valid and binding, even though it takes away a party's right to a jury trial, so long as the contract to arbitrate is enforceable. In addition to generally providing that arbitration agreements are enforceable, the federal and state statutes also provide mechanisms for the parties to enforce their agreements and the awards of the arbitrators. The statutes provide that if a party files a lawsuit in a dispute to which an arbitration agreement applies, the court must stay the litigation to allow the arbitration hearing to be held. If a party refuses to arbitrate, the courts have the authority to order them to arbitration. And once an arbitration award is issued, the statutes provide that judgment can be entered upon the award by the court and then enforced like any other judgment. And the grounds to overturn an arbitration award or to appeal its contents are severely limited. Arbitration has been a significant part of the legal landscape for many years in certain areas of the law. As mentioned before, labor agreements and commercial agreements frequently require for the resolution of disputes through arbitration. Arbitration standards have developed and administrative organizations have arisen to facilitate arbitration. The American Arbitration Association is the predominant American organization that promotes and administers arbitration. The AAA offers sample arbitration agreement language and rules for the conduct of arbitrations in commercial, labor, employment, construction, consumer, and international disputes. The AAA also maintains panels of arbitrators from which the parties can select the arbitrators for their case. Many arbitration agreements provide for arbitration through AAA, but again, contracting parties have great leeway in deciding how they want to arbitrate their disputes. In recent years, new and controversial issues have arisen in the field of arbitration. Traditionally, arbitration agreements have appeared primarily in contracts between relatively sophisticated parties who are well aware of the meaning and significance of arbitration. More recently, however, arbitration provisions have been included in consumer agreements, like credit card agreements or agreements for cell phone service. Arbitration provisions have also been placed in agreements for admissions to nursing homes or enrollment in private schools. In these situations, the parties have limited or sometimes no ability to bargain over the arbitration provisions, and oftentimes they don't understand the significance of the provisions if they read them at all. The question of enforceability of arbitration provisions in these contexts has resulted in a spate of litigation, with several cases reaching the U.S. Supreme Court. The effect of arbitration agreements in these contexts will continue to be a hot issue in American law.